Hello, Big Block family. I'm Luiey Haddad with Equity Legal, and we are your general counsel here at Big Block Realty. We're here to discuss what remedies are available to your client when a real estate sales contract falls through. Now, in most cases, someone selling a home is really eager to get to a closing and move on, quite literally. The last thing the seller will try to do is try to scuttle the deal and will negotiate when issues arise through a transaction. But once in a while, a home seller will back out, having gotten cold feet, receiving a better offer, or experienced a change in circumstances, or just didn't want to move forward with the sale. In those cases, there could be several remedies available to your buyer. Now, when a buyer backs out of a deal, a seller's main remedy is essentially obtaining the earnest money deposit that's left with the escrow company. Now, that might be different depending on the terms of the contract, but for the most part, that is what a seller is allowed to collect as a remedy in those cases. So what I'll be doing today is discussing with you what happens when a seller backs out and the buyer is seeking their remedies. Fortunately, a home buyer has certain remedies available if the seller wrongfully fails or refuses to perform their obligations under the contract for a real estate sale. One of the things that the buyer can proceed on is money damages for a breach of contract. Another thing is termination of the contract, return of the earnest money deposit, plus payment for reasonable expenses, or even specific performance, which is essentially getting an order of the court to require the seller to sell the property to the buyer. That's the most extreme circumstance, and generally courts are reluctant to force the sale of a property, but in some circumstances it is warranted, and I'll discuss those three remedies with you here today. Now, first, before we go rushing into court and saying I want specific performance, the first thing we need to do is look at the contract and see if the seller actually defaulted. Now, there are numerous consequences to a default. However, if there are contingencies or other variables within the contract that allow the seller to back out in a certain period, well, then the seller really didn't default, and they moved forward with the terms of their contract appropriately. For instance, if the seller and the buyer agreed to include a contingency that the sale is contingent on the buyer finding another home, the seller buying another home, and the seller in good faith attempted to do so, just couldn't do that by the time this home needed to close, then the seller could reasonably back out without defaulting on the contract. There would be no legal breach, and you would have no legal basis upon which to complain or sue. Your remedy would be to obtain your deposit back. Now, if the seller did not act in good faith and backed out after either contingencies were lifted or otherwise defaulted under the contract, you may be able to obtain money damages for that seller's breach. If you've been financially damaged by the seller's breach of the purchase contract, suing for money could be that option. How much can you ask for? Well, that depends on how much you are actually affected. If the seller acted in good faith and you are not otherwise financially impacted, well, the seller might be only liable for return of the earnest money deposit, plus interest and reasonable expenses. Now, reasonable expenses could be the cost of the title examination, the preparation of a survey, or even attorney's fees if that's required. However, if the seller acted in bad faith, it could allow you to recover additional damages. And those are issues you want to discuss with us so that we can walk you through the facts of your particular transaction and see if those damages are available to you. Now, in the event by the breach of the seller, the buyer could decide that they're willing to walk away and terminate the contract with the seller as well, and not proceed with a lawsuit against the seller. In those cases, you'll likely be able to negotiate the return of your earnest money deposit and potentially additional money that you expended during this transaction if the contract is not performed. Now, if the seller is able but unwilling to perform, which is to sell you the house, it might actually be possible for you to bring a legal challenge for what's called specific performance. This means you're asking for a court to have the seller actually sell his house to you under the terms of the contract that was breached. The court would order the transaction be completed according to that contract rather than compensate you monetarily for the breach. Specific performance is not a matter of right, but it's usually a matter of the court's discretion and also depends on the general laws and facts surrounding your circumstances. A court typically orders this only upon a finding that the purchase agreement lays out the essential elements, that the elements were breached, and that the buyer was ready, willing, and able to perform on their half of the bargain. Now, because real estate itself is unique in California and every home is different, specific performance can be a remedy that you can pursue in order to force the sale of that home. Now, the essential elements that are involved in a real estate contract typically would include the purchase price, the earnest money deposit amount, the down payment, a legal description of the property, financing terms, closing date, and method of payment. They may also include inventory on the property or specific conditions to the sale. The courts are understandably reluctant to force a homeowner to sell, particularly if the seller plans to remain in the property, as opposed to a situation where the seller is not in the property or otherwise acted in bad faith. The real questions to ask yourself is, number one, did the seller really breach the contract? And secondly, are you able to get your earnest money back from the home? At the end of the day, there are numerous factors to ascertain to understand whether or not your buyer has certain rights and responsibilities if the seller does back out of a deal. When that happens, you don't want to waste any time. You want to go immediately to your broker, discuss the issues, and discuss the issues with us here at Equity Legal so that we can put your buyer in a position to best follow through with the sale or obtain the remedies available to them under those circumstances. Don't hesitate to call us. We're always here for you and your clients to make sure that your transactions run smooth and that your rights and your clients' rights are being protected along the way. Thank you.